All right, let's jump right in and tackle one of the most critical chapters for your LSO paralegal exam. Chapter 7, all about the duty to the client. Think of this not just as a review, but as your tactical guide. We're going to break down exactly how to spot the issues and nail the questions on exam day. So here's how we're going to break this down. I call this our exam cracker funnel. We're starting big picture, and then we're going to funnel all the way down to the nitty-gritty details and the traps they love to set on the exam. This whole structure is designed to help you think like the exam writers and attack any question they throw at you.
First up, why does this chapter matter so much? Well, let me tell you, this isn't just about scoring a few points. Understanding this one core concept is really the key to unlocking the right answers across a huge range of scenarios you're going to see. It's foundational.
So, let's just frame our whole discussion with this one simple question. If you can get this concept down, you are already way ahead of the game. So, what is it? What is your single most important duty?
And the answer, the big one, is fiduciary duty. This concept is the anchor for this entire chapter. Honestly, almost every single rule we're about to talk about, from competence to honesty to protecting client property, it all flows from this one fundamental idea of trust. Just remember, you're the fiduciary, the client is the beneficiary. Their needs always come before your own. Okay, so you're probably thinking, great, I get fiduciary duty, but how is this actually going to show up on the exam, right? They're not going to just ask for the definition. Instead, they're going to give you a story, a fact pattern, and your job is to spot the triggers. So let's learn what they look like.
You see a scenario like this on the exam, alarms should be going off in your head. Ding, ding, ding. This is a classic red flag. It's testing your duty to avoid assisting in any kind of illegal conduct, like money laundering. You can't just accept it. You have a duty to ask more questions.
All right, what about this one? An elderly client who seems confused, and maybe their son or daughter is doing all the talking. This scenario just screams diminished capacity and undue influence. The exam wants to know if you can spot that your client's instructions might not actually be their own instructions.
Aw man, this one makes your stomach drop, even in a practice question, but it is a classic test. The second you read that a deadline was missed, your brain needs to go straight to error or omission. This trigger has a very specific 3-step response that you absolutely have to know. And our last trigger to watch out for, a client wants you to play hardball. This kind of fact pattern is basically the exam writers waving a flag in your face to see if you know the rules about improperly threatening criminal or regulatory proceedings just to get an advantage in a civil case. Okay, so we've trained our eyes to spot the triggers in a question. Now let's arm ourselves with the core rules you need to have down cold. These are your non-negotiables for the exam.
Remember that missed deadline trigger we just talked about? Well, here is your exam gold. It's the IRA method. First, you inform the client about the error promptly. Second, you recommend they go get independent legal advice. And third, you advise them that you might have to withdraw. IRA. Seriously, burn this into your brain.
Now, what about when you're handling a client's property, whether it's money or important documents? You've got 5 crystal clear duties. Think of it as a 5-point safety check. Notify them, label and secure it, record it, account for it, and if there's any confusion at all, you apply to a tribunal. It's a critical checklist.
You'll notice all these other duties tie right back to that fiduciary relationship we talked about. You have to be honest, right? Even when the news is bad. You absolutely cannot assist in anything illegal. You should encourage settlement when it makes sense. And of course, you have very specific duties when dealing with clients who might have diminished capacity or who are under pressure.
Okay, this is important. The exam doesn't just test the simple, straightforward rules. It loves to live in the gray areas, the exceptions, the nuances. This is where they try to trip you up, and where they separate the people who really know their stuff from those who just memorize the basics.
Let's really break this down because this is a super common point of confusion. Threatening to call the cops on someone just to get them to pay a private debt, that is improper. It's an abusive process. But notifying a regulatory body like the Law Society about conduct that genuinely falls under their jurisdiction, that is proper. It has a lawful justification. Knowing this difference is absolutely key to getting this type of question right.
Now for my favorite section, the traps. These are the classic gotcha questions where candidates stumble, usually by confusing 2 similar ideas or by missing one tiny but critical detail. Let's make sure that's not you.
All right, put yourself in the exam hot seat. You get a medical report for your client's case. It could be crucial, but the doctor attaches a note saying, "For your eyes only, do not show this to the client." What do? What's the one thing you must do?
And the answer is simple and non-negotiable. You return it immediately. And you don't even make a copy. Why? Because your duty of honesty and candor to your client is absolute. You cannot agree to keep secrets from your own client. This is a huge exam trap, so watch out for it.
Here's another common mix-up. The retainer is over and the client wants their file. What do you have to give back and what's actually yours to keep? Well, here's a simple way to think about it. If it was created for the client's case and they paid for it, like legal briefs, expert reports, evidence, it belongs to them. But your internal stuff, your time records, your accounting, your private working notes, that's your property. Know that distinction.
And that brings us to the final piece of the puzzle, the so what factor. Why does all this matter? Well, because when these rules get broken, there are real serious consequences. And you can bet the exam is going to test you on what happens next.
Look, a breach of these duties isn't just a wrong answer on a multiple choice test. In the real world, it can set off a disastrous domino effect. We're talking professional misconduct proceedings with the Law Society, getting your license suspended, being sued by your client for negligence, and completely destroying the professional reputation you worked so hard to build. These aren't just abstract rules, they're the guardrails for your entire career.
And I'll leave you with this thought. The duty to your client is so much more than just passing this exam. It's the absolute foundation of a long, ethical, and successful career. So as you study, remember the framework. Spot the trigger, know the rule, watch for the traps, and understand the consequences. You've got this. Good luck.